Yeah, it's coming from the store, like I was saying, on my way, to my grandmother's house,
One evening in 2010, Mustafa Willis was walking to visit his grandmother in Newark, New Jersey, when police stopped him on the street.
Put your hands up. I put my hands up. He said, don't move. Check me, place me under arrest. The sergeant said, tell me who gun this is and we'll let you go. And I said, officer, I don't know nothing about no gun. I'm not from around here.
He was arrested for having a stolen gun, a charge he denied. He says bail was set at $50,000, which meant he had to come up with $5,000 or 10% for a bail bond in order to go free. But at the time, he was making only about $1,200 a month after taxes as a truck driver's assistant.
Could you afford to pay $5,000 to get out of jail?
No, ma'am.
How long did you sit in jail for?
3 months.
During those 3 months, Willis lost his job, missed the funeral of a cousin, and developed high blood pressure, he says, from the stress of being in jail.
I just wanted to be home with my family. Like, that was really it. Like, it was just hell for me.
Willis got out after the judge reduced his bail, and eventually prosecutors dropped all the charges. But Willis and his family still had to pay back the $3,000 bond.
So Mr. Willis's story is not one that is unique. It was something that was all too common in New Jersey before January 1st, 2017, where we had a monetary bail system where people's the difference between whether somebody would get out of jail or not pending resolution of their case was the amount of money in their pocket and not based on anything that had to do with the risk that they posed of committing another offense. So today we're going to talk about the New Jersey system in detail and talk about what happens at first appearances with our clients, what happens at detention hearings when judges are making the decision of whether or not to hold somebody pending trial. But in order to understand New Jersey's new system, we have to start by talking a little bit about that old system, the one that Mr. Willis was charged under. So that system considered only risk of flight. And what I mean is that a judge setting bail before January 1st of 2017 could only consider whether or not somebody would appear in court. Their dangerousness or consideration of whether or not they may commit a new offense while on release wasn't something that a judge was allowed to consider.
But that doesn't mean judges didn't consider it. Of course, it was a predominant consideration often, but they could never talk about it. So there's always this subtext in any conversation about risk of failure to appear that we knew but weren't allowed to say was dangerousness.
Absolutely. And litigation that we tried in New Jersey failed to provide any sort of meaningful reform. There were a number of efforts in New Jersey by the defense bar and by civil libertarians to hold the court's feet to the fire when it came to imposing speedy trial provisions for those people who were held pre-trial. And our previous laws said that people had to be brought to trial within a reasonable amount of time, which was really something that was never quantified. And therefore, people sat in jail for periods of, I think routinely, periods of at minimum a year to 2 years before their cases went to trial. There was also efforts under the old system to use litigation to get judges away from money bail and to set bail only in amounts that people could truly afford to make. And those attempts really fell on deaf ears. So we had to imagine a new way to redesign the system. In October 2nd, in 2013, the Drug Policy Alliance published a report that was a snapshot of our jail population on October 2nd, 2017. And
2012.
I'm sorry, 2012, October 2nd, 2012. And what that report said is that because of the way the old system was working, was that 3/4 of our jail population was in jail awaiting their trial. About 12% of people were being held in jail on bails of $2,500 or less. And many people were unable to post higher bails, even on nonviolent offenses. The study also found that it was a really long time before people were able to resolve their cases. So it was an average of 314 days before a case was resolved. So you have about a year before people's cases were being resolved, which means that some people were sitting in jail a lot longer than that, some people a shorter amount of time than that. There was also no defined period in which the state had to indict someone. So typically, we were seeing, at least in Essex County, which was a county that Alex and I had practiced in a lot during our career, you'd see people sitting in jail for about 6 months, maybe 3, 6, sometimes closer to 9 months before a grand jury even decided whether or not there was probable cause to charge those offenses. And there's also this sort of dishonesty in the system. And what I mean by that is you had judges who were technically not allowed to consider whether or not somebody was dangerous in deciding what bail to set. But it was only human nature for a judge to look at somebody in front of them and to assess whether or not they were a danger to the community, and therefore set a money bail really high in order to prevent that person from getting out. And Judge Capicella, who is a judge of Passaic County Superior Court in northern New Jersey, describes that dishonesty this way.
At the same time, potentially violent people who had money easily posted bail and walked free, says New Jersey Superior Court Judge Ernest Capicella. Because the state constitution used to require bail for most cases, Capicella says judges did something problematic, setting bail extremely high in order to keep some defendants behind bars.
So, $500,000 bail, $1 million bail. If I set a bail on you and I know you can't make it, that's an excessive bail. That violates the 8th Amendment of the Constitution. It violates the presumption of innocence. It wasn't, in my opinion, an honest, intelligent.
So not an honest and intelligent system. It's cut off the last word there. So the old system was not one that was intellectually honest in that it didn't allow a judge to come out and say, I think that this person poses a risk to the community, and therefore I think that we should hold them without bail. And on the other end, it didn't allow for a system in which liberty is the norm and detention is a carefully narrowed exception. So what New Jersey did was establish the Joint Committee on Criminal Justice, which had members from all of the constituencies that you would imagine, from the ACLU, from the Public Defender's Office, from the Attorney General's Office, various organizations, and they came together to talk about the bail system and talk about creating a new bail system. Alex, if you want to talk a little bit about those meetings.
So in fact, what we were supposed to do, we got to our first meeting and we were told, we don't want to create a new system. We just want to figure out how along the margins we can make the current system more fair, whether they're speedy trial rules or rules on pretrial release, but we don't want statutes, we don't want constitutional amendments, we just want to tinker a little bit. And at this first meeting, this group of people who really couldn't agree on anything voted unanimously that there was no way to tinker with the system to make it more fair. The only way to make the system more fair was to fundamentally reimagine it and to transform it from a system that thought first about resources to one that thought first about measuring and managing risk.
And there is another webinar that we've filmed that talks in a lot more detail about the process of the Joint Committee on Criminal Justice and how they reimagined the system and got those reforms in place. So if you're interested in that, you can watch it on the NACDL website. In this webinar, we're going to focus in a little more detail, though, on what happens at these first appearances, what happens when these risk assessments are taken, and what happens in the detention process. So the new system, though, to put this new system in place, it required two things. It required, first of all, a constitutional amendment, because before January 1st, 2017, in New Jersey, there was a provision in the Constitution that required a monetary bail for anyone charged with an offense. So one of the things that we had to do is, in effect, take away the right to a money bail. The second thing that we had to do is enact legislation to create the framework for this reform. And we had the support of the Republican governor, the then governor of the state of New Jersey, Chris Christie, who I think went into this seeing this as a way to be able to protect the public by keeping people in jail prior to resolution of their charges. But in the end, I think Chris Christie really did become a believer, and we have to give him credit where credit is due.
Yeah, I mean, there aren't that many opportunities we get at the ACLU to talk about the places where we agree with Chris Christie, but this is really one of them. And as Jen said, he started out talking about we need to detain dangerous individuals. by the end, he never gave that up. But he was also saying things like, our current system that is jailing people simply because of their poverty is a modern-day debtor's prison. And we were kind of like, whoa, did he steal our talking points here? And so this really did bring together some incredibly strange bedfellows.
We now have a criminal justice system that will permit our judges to keep the truly dangerous sociopath behind bars, but will release those nonviolent offenders if only remained in jail because they're poor.
So you can see a little bit of that there. So the statute that we eventually enacted has 3 goals. 1, to ensure that the defendant appears in court. 2, that a person accused of a crime doesn't pose a danger to the community. And 3, although this one is one that we don't talk about very often, that a person accused of a crime will not obstruct the process.
And I want to throw a little cold water on all this. Those are the goals. But we're never trying to set up a system that guarantees the defendant will show up, nor are we trying to set up a system that guarantees that the defendant poses no danger. Instead, what we're trying to do is figure out ways to manage people who pose the most elevated risk of not showing up. Because everyone could get hit by a bus on the way into court or something like that. We're not trying to manage that. And by the same token, we're not trying to prevent every crime or anyone who's any danger. We're simply trying to say who are the people that pose the greatest danger and trying to manage that risk.
So the statute, right in the very beginning of the statute, said that it should be liberally construed to effectuate the purpose of relying upon contempt or criminal sanctions rather than financial loss. So right in the wording of the statute is that it should be liberally construed to not assign a monetary bail to a person who's charged with a crime. And that money bail should only be set when the court, it can't be satisfied that there's any other conditions of release that will do, and the accused person doesn't pose a danger to the community. So although our statute didn't go as far as to completely eliminate, to say you can never set a money bail, it puts money in the position of being the last resort before you'd have to move somebody into the detention category. So what we were looking at here is an attempt really to functionally take money bail out of the system. And this is the hierarchy of release under our new statute. So everybody starts with the premise that you should be released, that you should be at liberty until the resolution of your case. If that won't satisfy the 3 goals of the statute, then we move on to release with non-monetary conditions. If only those 2 things won't work, we move on to the 3rd, which is monetary bail. After that, it's monetary bail plus conditions, and then finally detention on a motion by the state. So you can see that the default position is release or release with some sort of non-monetary condition before we ever have any discussion of money under the new system.
And even within that hierarchy, there is another hierarchy, which is to say when you're thinking about the non-monetary conditions, the judge may only impose those conditions if she determines them to be both necessary and the least restrictive. So, of course, a judge could say, I'm going to put everyone on GPS monitoring and home detention, but if that's not the least restrictive condition that will achieve the purposes of the statute, the judge is forbidden from ordering it.
So one of the other things that we have going on with this is we have the statute, we have the court rules, but we also have in New Jersey Attorney General directives that are written by the Attorney General's office to guide prosecutors in making decisions about how to either charge cases or how to handle cases and what recommendations to make to the court about conditions and detention and money bail and those sorts of things. And one of the things that was to the Attorney General's office credit in New Jersey that they came out and said, looking at the language of the statute, was this, that if a prosecutor thinks that money bail is the only thing that's going to keep a defendant showing up in court or keep them from being rearrested for a crime.
Actually, money under the statute can only deal with the failure to appear in court. You're not allowed to use money for danger.
Sorry, sorry. So if a prosecutor thought that money was going to be the thing that would make somebody appear, that they should seek detention. So effectively, what the prosecutor was saying through the Attorney General directive is we want to take money out of the system completely. If money is the only thing that's going to make somebody show up in court, the person is probably not going to show up in court, and therefore you should recommend detention. And that was the rules that they wrote in the directive.
And then what they went a step further, and they said, but if you're going to seek money bail, you have to be confident that the defendant can make it. So while the statute doesn't forbid it, and the courts have yet to forbid it, we have the head prosecutor in the state saying, don't ask for an unaffordable amount of money. In the rare instance where you're going to ask for money, you have to ensure that it's an amount the defendant can make.
So who's eligible for detention? Under the new statute, it had to be someone who was arrested after January 1st of 2017, and they had to be arrested on something called a complaint warrant. So this is where we talk a little bit about the specifics of New Jersey law and the difference between a warrant and a summons. So if you were arrested on a summons, what that is just a piece of paper telling you you have to come back to court at a certain date to answer to the charges. In that case, under our old system, no bail would have been triggered. It's an automatic sort of release. You're released and you're at your liberty until you come to court for your first court appearance, and you would never go through any sort of bail setting process. Under a complaint warrant, that would be under our old system. Those would be the offenses where a bail would be set. You'd have to pay the bail, and then you would get out. So it's only those cases that where you were charged on a warrant that you become eligible for detention under the new statute. And here's a list of the eligible crimes. I'm not going to go through all of them.
The short answer is everything. More or less everything. Any what we call indictable offense in New Jersey, which means what most people call felonies, is eligible. Plus disorderly persons offenses, which are more equivalent to misdemeanors when they are domestic violence cases. So it's a lot of cases that are potentially eligible. However, there's still some protections.
And here the Attorney General's office stepped in and they wrote guidelines. And again, these are guidelines to prosecutors. But in the Attorney General's directive, they said that whenever somebody is charged with crimes that you would imagine, right, the most serious offenses, you have to apply for a warrant. That's the Attorney General's directive. We're always going to apply for a warrant in a murder case or an aggravated sex assault case, a robbery, carjacking, crimes of the most serious nature. There's a presumption for a warrant. Prosecutors probably should file for a warrant in other felony cases. So these would be your second and third degree felony cases. You can see a list of them here. Including cases where for some reason the PSA results, so the risk assessment results, aren't available or something like that. If there's some sort of an emergency, then there would be a presumption for a warrant. But those are typically the cases where you would file for a warrant on. But the Attorney General directed its prosecutors that there's a presumption for a summons on these disorderly persons cases that Alex was talking about, the domestic violence disorderly persons cases.
The non-domestic.
The non-domestic violence disorderly persons cases, and anything that's not included in the other two lists, which really we're talking about here mostly your third and fourth degree types of cases. So we have a whole category of cases, and third and fourth degree cases include crimes like burglary and thefts and drug possessions, a whole category. Drug distribution, or the whole category of cases where now the presumption is that people are released on a summons. And as we'll see later, we've seen the rate of people released on summonses pretrial go up dramatically with the advent of the new system. Okay. So when people come to court, the first thing that happens is we call it the first appearance, which is shockingly their first appearance in court. And at the first appearance, they're given something called the public safety assessment, which is the risk assessment tool that New Jersey decided on, and we're going to talk about that more in a minute. So everybody who's arrested on a complaint warrant is taken into custody for no more than 48 hours by statute. However, the Chief Justice and the Administrative Office of the Courts said they wanted people to see a judge within 24 hours, and we're really pleased that last year 81% of the accused have seen a judge within 24 hours.
And that's just a recognition by the courts that we all know that detention has huge costs for defendants, right? It dislocates them in lots of ways. It impacts their cases. But the dislocation, the possibility that they'll lose their job or their apartment or custody of their child, most of that happens in the first 3 days. I mean, that's the work that the Pretrial Justice Institute has been kind of groundbreaking on this 3 days count campaign. It's a really big deal. And so recognizing that while the legislature said we're going to give courts 48 hours, the court said we generally don't want to take 48 hours. We want to try and get it done in 24 hours.
So when people come in, they're scored on something called the Public Safety Assessment, and this is a data-driven tool created by Luminosity, the company's Luminosity, that was validated on 1.5 million cases, research in 7 jurisdictions, and it is the risk assessment tool that the court decided on. In our statute, it said that the risk assessment tool had to be one that has been validated. And that was important, and that was one of the things that kind of went into the selection of this tool. Another reason that it was selected is because it doesn't involve an interview. It doesn't involve an interview with our clients. Where there's an opportunity for somebody maybe to say something or give information to the risk assessment interviewer that may incriminate them in a case or may be considered in an unfair way in the case. It also only takes into account criminal history statistics and failure to appear and age, sort of objective biographical data. That is not to say that with any system, when we're talking about sort of the inherent racial disparity that's baked into our criminal justice system already, that isn't something that, if you're in a community that's been over-policed, or you're in a community where you might be more likely to encounter the police and be arrested and be charged in the past with crimes or convicted of crimes in the past, that's not creeping into the tool. But I guess to the extent that we could, we tried to pick the most objective tool.
I think that's fair. It's also worth saying our statute requires that the tool that is selected not rely on race and not exacerbate racial disparities. And I think, look, no one is going to want a tool that says, well, I'm going to add points to your score. I'm going to increase the chances of your detention if you're black. No one is, as far as I know, suggesting something so crazy. I also don't think people are thinking things as sloppy and crazy as saying, well, we won't use race, we'll use zip code or some proxy for race, frankly. We're also skeptical of places that use arrests and things like that because we know that they're just simple replications of bias, kind of garbage in, garbage out sort of thing. We have those same concerns even with the data points that the PSA uses, which is to say convictions and failures to appear, so we know that if you're arrested more often, your chances of failing to appear are going to increase. However, at least my own view is that while those are concerns and things we need to monitor and be careful of as we go forward, they're also exactly the data points that judges were using under the old system to make decisions on top of their own biases. So under the old system, the judge would look at how many times the person had been convicted, how many times the person had failed to appear, and might superimpose on top of that racism or gender bias or class bias or whatever bias. Now, at least if they do that, we can see it. There's more transparency, and there's not enough transparency, but there's more transparency in the decision-making process, which gives advocates the opportunity to challenge biased decision-making.
So there's things that the public safety assessment tells us about a person, and quite frankly, there's things that it doesn't. But what it's supposed to tell us is their likelihood of failing to appear in court, their likelihood of a risk of reoffense, and if they commit a new offense, what is the likelihood that that new offense would be a crime of violence?
And I think there are important things to say about all of that, and it gets back to my last point. But first on failure to appear, and this is important for advocates, because we can't just accept numbers like this and say, oh, golly, my client has a high score for risk of failure to appear. We need to disabuse judges and prosecutors of the fact that failures to appear as a general rule are people fleeing to non-extradition treaty countries and they're just on the lam. More often, it's that people are poor. People find it hard to get to court. People don't have childcare. They don't have transportation, or they simply forgot. And so we need to be clear that we don't conflate failure to appear with flight. And the same thing with risk of reoffense. We don't have a way to measure, and the tool doesn't even pretend to measure, the risk that someone will commit another offense. Instead, what the tool measures is the risk that the person will be arrested for committing a new offense, which, of course, has built into it policing practices and things like that. So there's a certain value in the precision. And again, I still think this is better than what we had, but we can't let our opponents, be it prosecutors, judges, whomever, co-opt what these tools actually measure.
So what we have is a risk-based system of pretrial release. And what we mean by that is it's really, the system is designed to measure how we measure the risk and how we manage it. It's not designed to say that there's going to be no risk, right? We can't have a system where there's absolutely no risk. Inherent in a system where liberty is the norm, there is going to be the risk that people won't appear and that people may be arrested for committing a new offense. But what the tool aims to do, and this is a slide, one of Luminosity's slides, but what this tool aims to do is say, how do we measure those risks? And then how do we manage those using pretrial services and using the justice system to sort of manage the risks that show up in the risk assessment? So one really important thing to remember, and one of the things I always tell lawyers when I'm training lawyers on the risk assessment and using risk assessment tools, and I think this would apply to any risk assessment tool, not just the one we've chosen in New Jersey, is that the risk assessment is part of the process. It is not the process. And in the beginning, when we were talking to lawyers and training them and getting them ready to go into courts and represent people using this new tool, people seemed to be kind of stuck on the numbers that the tool spit out and thought that everything would sort of live and die on the numbers spit out by the tool. But that is not the case. The risk assessment tool is part of the process. It's not the only process, and it is not a substitute for a lawyer's advocacy, be it a prosecutor or a defense attorney, the advocacy that they're going to bring to show that their client is about more than the number spit out by the tool, and then there may be reasons that the tool scored them a certain way, or there may be reasons why, even though they are scored a certain way, the judge shouldn't go by the score that the person received.
The Arnold Foundation came up with the Public Safety Assessment Tool, and it says that tool is in no way meant to replace the discretion of the judge.
And they, as I mentioned, can take into account any factors that they're aware of outside of the risk assessment. So the objective of the risk assessment is in no way to determine what happens in the outcome of the case.
So the risk assessment isn't used to determine the outcome of the case because there are so many other factors that are going to go into the judge's decision making. And it certainly, the risk assessment not only doesn't determine the outcome of the case, but the risk assessment doesn't show a judge a true and accurate picture of exactly who this individual in front of them is. And there's a number of things that we can rely upon that are outside the risk assessment tool. For prosecutors, we had to prepare our lawyers that prosecutors were going to rely on, for example, juvenile history. Our risk assessment tool does not contemplate juvenile history. A person's juvenile history is not a part of the score they get. So if the accused before the court is 19 years old and has no priors, but has 7 juvenile adjudications, the prosecutor is going to talk about that.
Yeah, I mean, one of the first cases that we litigated on pretrial justice reform after January 1st, 2017 was a case called State versus CW. And in CW, the defendant was charged with soliciting a child for sex, and his score went through the system and it was very low. It was like a 1-2 or a 2-2, which we'll talk about at some point later. And the judge ultimately released the guy, and the state appealed, and they said, wait, this is crazy. Of course he doesn't have any convictions because he just got out of juvenile detention where he had been for the last 3 years on facts identical to this. So he had no opportunity to fail to appear because he was in jail, and he had no opportunity to commit an offense as an adult because he was in jail. And so in that case, ultimately the appellate court remanded and the judge detained the person. Now, the case would be very different if you had a 40-year-old defendant and the prosecutor stood up and started talking about her juvenile record.
Absolutely. So juvenile history is one thing we can see considered in very much the same way out-of-state convictions. If somebody has an out-of-state conviction and no prior arrest in New Jersey, of course, prosecutor is going to bring that up. And then if somebody is, if it's a domestic violence case and the victim may be the same in the new case as a prior case. And, you know, that goes for both sides, though. On the defense side, there's a whole host of things that we can bring up in support of our clients that are not contemplated in the tool. And it's all of the human and family factors, whether they're employed, if they have ties to the community, family support, lack of juvenile DV, out-of-state convictions, et cetera. So it's really important for attorneys working with risk assessments to be mindful that it's not a substitute for advocacy. It's not a substitute for storytelling. It's not a substitute for doing everything we can to get the judge to see that our client is a human being who has all sorts of positive things going for them, and they are a person that should be at liberty until the day of their trial or some a resolution of their case.
And like Jen, I was going around New Jersey before the statute was effective, telling people just this. You need to advocate. You need to tell your stories. And I was also crossing my fingers and hoping that judges were going to have gotten the memo that the tool was part of the process. It wasn't the process itself. And it is proven true, which is to say judges are rejecting recommendations that come from the decision-making framework that are informed by the public safety assessment all the time, and they're rejecting them in both directions, which is to say sometimes when the person has an artificially low PSA score, the judge is nonetheless imposing onerous conditions on them, and sometimes because of facts that come out through advocacy, and sometimes despite a very high score, a judge is releasing people because of things that come out in advocacy.
So when an attorney comes to court, another thing that they get, so they get the risk assessment score, they get that from the court. They also get something that we've called the PLER. What does the PLER stand for?
Preliminary Law Enforcement Investigation Report, I think.
Gold star. That's what it means now.
Good.
Okay, so the PLER is something that includes the factors that are relied upon to calculate the PSA, biographical information, current charges, recommendation of pretrial services. So it contains sort of a distilled set of information about all of those things. On a case note, State versus Moore, and I know Alex has argued every single one of these cases in the Supreme Court, so I'm going to let him talk about State versus
This
Moore.
one, I want to be clear, we lost this one in the appellate division, not in the Supreme Court,
sorry.
but we did lose it. The question was, okay, great. So essentially, I think of a PLER kind of as a table of contents, right? It tells defense counsel everything that the state has. So it's not all of the discovery, which we'll talk about separately, but it is also a list of all the discovery. So there would be a checkbox that might say we have DNA or we have a fingerprint. Doesn't mean you get all that stuff, but it's just telling you what they have. So it's quite a useful tool for defense attorneys. And after the court made clear that they were going to provide some discovery, some county prosecutors in New Jersey said, oh, you know what? I guess here's what we'll do. We just won't make a PLER, then we won't have to turn it over. And the court in State v. Moore, and it was kind of a technical statutory interpretation case, said, yeah, they're not required to. They have to turn over any available PLER. And in this case, if they don't make it, it's not available. But I will say, of the 21 counties in New Jersey, I think 18 or 19 are still creating PLERs and providing them to defense counsel.
So the risk assessment tool itself considers 9 factors in coming up with the score. And we're going to talk about later what the scores look like and what they mean. But there's 9 factors that are considered, and they're the factors that are listed here. Those 9 factors are put into the system. They're pulled from criminal history, jail records, court databases, and there was a lot of technology infrastructure that had to be put into place to make this reform happen, because we needed to consolidate all these systems so that the risk assessment tool could access them. There's, like I said earlier, there's no interview with our clients. We're not relying on any data that's provided directly from our clients. It all comes from biographical information, fingerprints, and databases that are available to the risk assessment tool from those technology databases. But it pulls up information on the 9 factors that you see on the screen. And we're just going to kind of quickly go through each of the 9 factors to give you an understanding of what this tool contemplates. The first is age. Pretty self-explanatory. You're going to get points for being young, and you're going to not get any additional points if you're over 23. Violent offenses. So it considers whether or not the violent offense, whether or not the new offense is a violent offense or an attempt or conspiracy to commit a violent offense. It also considers whether you have any pending offenses. And by pending, they mean not resolution. So if you're on probation or parole, that's not considered a pending offense. It has to be an open offense that there's no resolution at the time the new offense is alleged to have been committed. It also has to be a disorderly persons, and as I said, that's a little bit of a creature of New Jersey law, but think misdemeanors or above. So not a traffic offense or what we call petty disorderly person, which would be like a very low level.
Has to have a maximum sentence of 6 months or greater. If it doesn't have that, it can't. It doesn't
count. And then if it's the pending offense has to be unresolved, like I said, and it can't be a deferred disposition. So if you have some sort of deferred disposition, we have PTI in New Jersey, which is the name of our deferred disposition program. So if your case is deferred, that doesn't count either. It has to be an unresolved case. Prior offenses are also counted. If you have a prior disorderly persons offense or a prior indictable offense, which is 4th degree or above, that's going to count. And as I said earlier, our tool doesn't take into account juvenile adjudications. The tool also contemplates prior violent offenses, including disorderly persons offenses. So simple assault in our jurisdiction is a disorderly persons offense, a misdemeanor, or the equivalent of a misdemeanor, but it's considered a violent offense. Domestic violence, simple assault, is considered a violent offense. Interestingly, guns are not considered nonviolent offenses, a possession of a gun or a possession of a weapon for an unlawful purpose, and again, not juvenile offenses.
I think you misspoke. They're not considered violent offenses for the purpose of this part of the analysis.
Absolutely. And then failure to appear. And this is, you'll see when we get into the mixture of the calculations and what they do to the score, failure to appear is probably one of the biggest things that will kind of jump your score on the PSA, because failure to appear before is, according to the risk assessment, a strong predictor of your failure to appear in the future. So if we have two types, with the failure to appear within 2 years or more than 2 years. So those would be the two types. So if you fail to appear within the last 2 years, it's going to be scored one way. And if you fail to appear longer than 2 years ago, you're going to get less points added to your score, but still some points added to your score. And just a note about failures to appear. If somebody, for example, might be bench warranted by a judge who, you were supposed to be in court at 9, you show up at 10, the judge issues a warrant, but you show up at 3 o'clock and the judge recalls the warrant, that does not count as a failure to appear. It has to be on a different day. So you're a no-show one day if you show up another day. And it's predisposition only, which means if you have a failure to appear on a violation of probation, that doesn't count. And it's only counted, and the failures to appear are only counted once on an individual case. So prior sentence to incarceration is another one. So if somebody has a single sentence of more than 14 days, that is going to count as a prior sentence to incarceration. In New Jersey, we do have an opportunity when we're sentencing people, if somebody's getting probation, to either have the judgment of conviction read probation or read time served. So let's say somebody's been in 56 days. If they plead to 56 days as a condition of probation, that's going to count as a prior sentence to incarceration. If their judgment of conviction just reads probation, that is not going to count under this. So one of the things that we've been doing is educating our lawyers that not only do we have to look at where our client has been, but what happens if our client does, in the unfortunate event, show up in court again, protecting their judgments of conviction and protecting the record as much as possible so that in the future, these things count as little as possible towards their score.
Right. This is a perfect example of how even a tool that is really carefully done and clearly trying to minimize bias to the extent possible misses the mark in a certain way just in how you measure prior sentence of incarceration, because we know that all those time-served pleas that used to exist weren't because the difference between someone who had 13 days as a condition of probation and 50 days as a condition of probation wasn't because the sentence was intended to be harsher. It was because that person's poverty kept him in jail longer. So the reason we have this reform is acknowledging that was a failure of our system. That was bias built into our system, but yet it is potentially leading to greater scores, which is why the advocacy piece is so important, which is why, right, the score is going to be elevated if your sentence was 15 days as a condition of probation. But if you're a skilled advocate, you should be telling the judge, if my client only had a couple of nickels to rub together, it wouldn't have counted as a prior sentence to incarceration. This wasn't a judge determining that he had done something so horrible he should go to state prison. This was a guy who was too poor, who couldn't bail out. And the thing, and I don't want to steal the thunder, Jen made a really strong point about advocacy before, but it is so important. I mean, when we talk about on the failures to appear, do you think there's a difference on a failure to appear if the person moved to Georgia to avoid criminal prosecution or if they were in the hospital? Of course there is, and no judge on earth wouldn't think there was a difference. And if you're not bringing that to the court's attention, you're letting your client down. But as we were doing this tour, trying to sell people on this reform and making sure they were going to do this advocacy, we didn't know the extent to which Dr. Van Nostrand's idea that it's not the process, it's just part of the process, was going to be true, which is to say, how much were judges going to be slaves to the tool? And I will say, I was afraid that they were going to over-rely on the tool, despite the fact that the system is not set up that way. It's easy, it's lazy, and we were afraid of it. And what we've seen, and I know I've said this, but it's so important because you have to make sure in your system judges know that they cannot be slaves to that tool. They must be able to hear advocacy and deviate from it in either direction.
So the way this works, you get the 3 scores, and there's going to be point values assigned to each factor, and there are different sort of combinations of factors that'll go towards the score. I think it's better to just move to the next slide to explain what we mean. So this is sort of an overall snapshot of what factors are used where. So you can see, for example, your age doesn't figure into the failure to appear score or the NVCA score, which is the new violent criminal activity. Your age is you only get a point if you're young for the new criminal activity, and so on. And you can go down the list and see what 4 factors are considered when we're talking about somebody's failure to appear versus the 7 factors that are considered for the NCA and the 5 that are considered for the NVCA score.
But I think just one more thing that's important, and we don't have a slide on it, but this information is public, and that's really important. And not only is this information, these checkboxes, public, but we know how much each factor counts in calculating the scores. And that, to me, is an absolute prerequisite to a decent system. If this is all behind closed doors and opaque and attorneys don't know why their client has an elevated score or a reduced score, then the system can't work because you can't have true and meaningful advocacy.
And we do have slides on it.
Oh,
so
good.
I'm going to show them to you.
Just setting you up.
No, that's perfect. So you can see here for the failure to appear score, you can get a max score of 7. So if you rack up 9 points here, you're not getting any more than 7 from your FTA score, and you can see the weighting of the factors. So if you have a pending charge at the time of the offense, you're going to get 1 point. If you had prior failures to appear, you can get 1 point, 2 points, up to 4 points, and so on. So this is the combination of factors that go into your new criminal activity score. It's a maximum score of 13. And again, you can see that here, if you have a pending charge at the time of the offense, you're going to get, I think it's 2 points. 3. And then you can go down the list and see how those factors are scored. And then there's this new violent criminal activity flag. And it's important to remember that the flag is not an access. So when we talk about the score, you're going to get 1 number for failure to appear. You're going to get 1 number for new criminal activity. The new violent criminal activity flag is just that. It's a flag that says, if this person commits a new offense or is arrested for attempt or arrested and charged with a new offense, it is more likely than not that offense is going to be a violent offense.
There's an elevated risk that the crime they commit will be a violent one. It's a yes or no question, basically.
So if you score 3 or above, you're going to... 4 or above, you're going to get the violent flag. We'll have to check on that.
We'll check on that. I think it's 3 or above.
We went back and forth on this.
Yeah.
Okay. So, and then there's a weight conversion. So if you'll notice, you'll see when we show you the matrix, you can get up to 6 points for a score of 6 for failure to appear, a score of 6 for new criminal activity. So it's 1 to 6 scale on each axis, and then whether or not you get a flag.
So in other words, you convert the score that's 1 to 7 and the score that's 1 to 13, you convert them on to a scaled score of 1 to 6 for each one.
So you can see if on NCA you got a 13, your score would actually be 6 on the axis, and we're going to show you a little bit later the matrix that plots the 2 numbers and what happens depending on your score. But again, I think we've beaten this point that this is not a substitute for advocacy, for judicial discretion, and for legal research. So once the raw score is calculated, once the score is calculated, the next thing that happens is we go through something called the decision-making framework. And what that is pretrial services, our pretrial services team, which is a newly developed organization because of the new law. We now have a whole pretrial services department. And one of the things that they do is they take the score. So let's say somebody is a 4-3, and they look at that, and then they make a decision about whether or not to recommend to the court that that person be detained. So regardless of someone's score, you could score 1-1, which is the lowest possible score that you can get under the tool. If you're charged with murder, pretrial service is going to recommend that you be detained. And if you're charged with escape, aggravated sexual assault, first-degree robbery or carjacking, or certain weapons offenses, their recommendation is going to be for detention. Doesn't mean the judge has to do it. Doesn't mean that the defense attorney is not going to argue vigorously for that person to be released. They will also always ask for detention if the PSA resulted in the flag, the violence flag, and the current offense is a violent offense. So you have a current violent charge and the flag. They're going to recommend detention in that case as well.
And we're currently litigating the extent to which that recommendation can inform judicial decision-making, which is to say, under our statute, there are presumptions. There's a presumption of detention if you're charged with murder, and there's a presumption of release if you're charged with everything else. It's murder or crimes that carry life have detention, and everything else has a presumption of release. And the question is it enough to overcome that presumption of release that pretrial services has recommended detention? Our view, and I think the statute is pretty clear on it, is no, but there's currently a case pending before the New Jersey Supreme Court that the public defender and the ACLU have participated in, where that is kind of up for debate.
So this little clip shows the PSA in action, so to speak.
In the new system Capicella helped devise, judges and attorneys now rely on a public safety assessment, or PSA, to predict the risk a defendant poses. A computer algorithm evaluates 9 risk factors, like whether defendants have prior violent convictions or failures to appear in court. John Harrison oversees the new pretrial services program for Passaic County.
Now, if someone fails to appear in the last 2 years, it goes up.
Defendants receive 2 scores from 1 to 6.
She results as a 5-4.
The scores predict the likelihood the defendant will fail to appear and commit new criminal activity. The lower the scores, the better the chance the PSA will recommend the defendant be released.
So there you can see how the system actually shows up on the screen and what the lawyers are seeing in court. So here's the matrix. We call it the matrix. It sounds like the movie, right? The matrix. If you score 1-1, you're in the green, and that's the recommendation there would be release on your own recognizance. On the other end, in the red, you can see the opposite end. If you're a 6-6, that would be somebody who likely the recommendation would be for detention. And then you'll see all the different permutations in the middle, and we're going to talk about the kinds of monitoring conditions that those people may be released on. And pretrial services, again, is the organization. So when we go back to this idea of measuring and managing risk, they're going to help the court measure the risk by being the people who conduct the PSA and make the recommendation to the court after going through the decision-making framework. And then once a person is released, they're also charged with supervising that person and monitoring them on the conditions that were imposed by the court. And this is a little bit difficult to read on the screen, but I guess if you're watching at home, you can pause it and you can take a look at it. But it shows the different monitoring levels that people have. You'll see anything from, on the lower end, calling once a week, in-person reporting once a month or twice a month, on up to things like electronic monitoring, which is, we're trying to very carefully narrow the use of electronic monitoring, but that's one of the more serious restrictions that somebody could be on pretrial release.
The idea is that they're increasing restrictions or obligations as you go forward. The only condition that can be placed on people at the top level is hardly called a condition, which is New Jersey is now doing what dentists around the country have been doing for years now, which is sending you text message reminders the night before your court date. dentist appointment, whatever it is. And what the data show is that people show up a lot more when they're reminded, which I think supports the point I made earlier, which is that most people who fail to appear aren't fleeing. They've forgotten or have other obligations. And so, but the idea between these pretrial monitoring levels is you should be as high as possible, which is to say as few restrictions as possible, because the data show that over-conditioning, putting conditions on people that they don't need, actually increases their rates of failure on pretrial release.
And then there are alternative conditions, and although these are not offered in the matrix, and many of them are not even available necessarily through pretrial services, we can always ask judges to do things to keep people from being detained. So we can always tell a judge that our client is employed and ask him to make that one of the conditions of release, or that they're in some sort of mental health or drug treatment program, and ask the judge to consider that before a more restrictive alternative. And then there's detention. So sometimes prosecutors will move for detention in our cases if they're not satisfied that any conditions of release will meet the goals of the statute. And under our new statute, only the prosecutor can file a motion for detention. We can't, although I don't know why we would. A judge can't. So a judge, if a prosecutor and a defense attorney don't think that somebody needs to be detained, a judge can't say, well, I'm going to try to detain them anyway. It's only the prosecutor that can file and move for detention. And they can do it at any time. And then if detention is requested, then there is a hearing. That hearing is held within 3 to 5 days of the first appearance. And if the person is detained, that's when all of our speedy trial provisions will kick in. So the speedy trial provisions only apply to people who are detained. They kick in, and we're going to talk about them more specifically a little bit later. The standard of proof at these hearings is first probable cause that the defendant committed an offense, and then clear and convincing evidence that no conditions of release would satisfy the 3 goals. There is a rebuttable presumption only for murder and any case where there's an extraordinary term, an ordinary or extended term of life, as Alex said earlier. Those are the only cases where we say the presumption is for detention. For everybody else, the presumption is that there's some conditions, some combination of conditions that will satisfy the goals of the statute. And preponderance is the standard for rebutting the presumption. In discovery, one of the nice things about this is previously under the old system, not only did we have this long time period before somebody would be indicted, but we also had no access to discovery about the case, or very little discovery about the case until an indictment was handed down by the grand jury. Now, if the state makes that decision that we're going to move to detain this person, part of what comes along with that is that they have to give us discovery, or at least that discovery that they're going to rely upon in support of the detention application, or is relevant to the detention application. And that includes all evidence in the possession of law enforcement. And the argument is that if the state doesn't turn it over, the prosecutor can't rely on it. But there was a case called State versus Robinson. I'm just going to have Alex talk about Robinson and that decision and what that means for these detention cases.
So Robinson was the first pretrial justice case to go before the New Jersey Supreme Court in 2017, and it was an ID murder. And what the state did is the investigator spoke to 2 witnesses who identified Mr. Robinson as the shooter. They had reports from those witnesses, but they didn't rely on those reports. Instead, they had the report that the investigator did. And he said, I spoke to some people and they said Robinson did it. Therefore, I'm asking you, Judge, to detain him. And the state said, well, that's what we're relying on. We're relying on the investigator's report. And so that's what we're going to turn over. And the court said, the trial court, the First Appellate Court, and the Supreme Court all said, no. It's not what you're relying on. It's that which is related to that upon which you rely. So in that case, in Robinson's case, they had to turn over the photo arrays, the statements that the witnesses had given, any reports related to the identification process. Now, as that case gets prosecuted, they might also have a fingerprint or something, but they're not relying on that. It's not related to what they're relying on. They don't have to turn that over, but they do have to turn over anything related to the facts upon which they rely and anything exculpatory.
So at the hearing, the rules of evidence don't apply, but the defendant has several rights at the hearing. There is, of course, the right to counsel. There's a right to testify. There's a right to present witnesses. We'll talk about that in a minute. It's a right to submit exhibits, to cross-examine any witnesses called by the state, and there's also an opportunity to present information by proffer. I'm going to give you a case note, State versus Ingram, and have Alex talk a little bit about the right to call witnesses, which is probably one of the most hotly contested.
This is actually
issues.
about to cross-examine
witnesses.
So I'll talk about both. I'll talk about Ingram. And so in Ingram, this was another case that we lost. This was the second case to go before the New Jersey Supreme Court. And in that case, the question was, there's a right in the statute that the defendant has to cross-examine any witnesses who testify. And the question is, can the state proceed without calling a witness at all? And we argued that implicit in the right to cross-examine is an obligation for them to call a witness. And the court said, no, we're going to read the statute exactly as it's written. It doesn't obligate them to do it. It says they can proceed by proffer. We're going to allow them to proceed by proffer alone. I will say prosecutors have taken the court up on their invitation to proceed by proffer alone. I don't think since day one the state has called a single witness in these detention hearings. But that doesn't mean the defendants can't call witnesses. There's an unquestioned right for them to do that. We are going to have a case at the New Jersey Supreme Court in March, a case called State versus Leo Pinkston, where the issue is, may the defendant call an adverse witness? In that case, a police officer who the defendant thinks is going to be able to provide favorable information to the defense theory of the case.
So the factors that go into the detention decision are, like we said, beyond the risk assessment. There's a number of factors. The risk assessment score, sure, is going to be one of the factors that the court's going to consider. The recommendations of pretrial services. Pretrial services doesn't always make the same recommendation that is on the risk assessment score. The nature and circumstances of the offense, the weight of the evidence, the history and characteristics of the defendant. We have here the Johnson factors. Our old bail case was called State versus Johnson, and that delineated a list of factors that courts could consider, not risk that they would commit another offense or a dangerousness, but all the factors they could consider in considering whether or not somebody was a flight risk or a risk of failure to appear. All those factors can still be argued to the court, things like ties to the community, employment, marital status, all that stuff. Not marital status, I'm sorry, family status, all of that. And then now, of course, they can consider danger to the community as well.
Let me just say, I think one thing that's critical, and we haven't talked about it, I guess we do talk about appeals later, but these are in addition to the fact that these are the things judges may consider, judges are being required to give statements of reasons when they make certain decisions. And so we've seen cases where judges have relied on kind of the old lazy method of doing things, where they say, like, well, I considered his ties to the community and I didn't find them sufficient, and there's no real meat to it. So we litigated a case where the defendant was young. He was maybe 23 or 24, and he had lived in a town called East Orange his entire life. He had gone to East Orange High School. His parents lived in East Orange. He had since moved out with his parents, but still had his own apartment in East Orange, and he worked as a delivery person. And the state argued, and the judge accepted, that because he didn't have children or a spouse, he didn't have sufficient ties to the community. That's the old system, just a kind of checkbox, no analysis. When we got to the Supreme Court said, what do you mean he doesn't have ties to the community? What more ties could this person have to the community? He's lived in the same place his whole life. So there is a real meaningful analysis of these factors, which puts more onus on defense attorneys to advocate and build a record that either says, these are the positive characteristics that support my client's release, or that rebuts the notion that their client is a flight risk. One more case, we had a case that the Supreme Court just decided called State versus SN. And the state's major theory in SN was 50 years old and charged with an aggravated sexual assault against his ex-stepdaughter, effectively. And one of the state's theories on risk, and he had never been arrested before, one of the state's theories on risk of flight was he wasn't born in the United States, he's a dual U.S.-Canadian citizen. Well, defense counsel was able to get on the record the following facts. One, he was adopted as an infant by a family in New Jersey. He's born in Canada, adopted by a family in New Jersey, with whom he lived for his entire life, except when he cohabitated with the victim's mother. He had once met his birth mother when she came to New Jersey and he got a restraining order against her. and he had never been to Canada and didn't have a Canadian passport. So, armed with information like that, if the defense attorney is able to build a record like that, it's easy for the court to say, that doesn't indicate an elevated flight risk, that he knows and doesn't like one person in Canada. That's hardly, proof that he's on the next plane.
So we've been talking a lot about the role of advocacy and talking about the judge's discretion in either following along with the PSA score or not. And I think this gives you two quick examples of two people coming before the court and being scored with different scores, but being treated differently by a judge who's using all of the information at his disposal to make the decisions.
If there's a serious crime or a high PSA score, the prosecutor can file a motion to detain. That triggers a second hearing held within about a week. Lawyers present evidence arguing whether the defendant should be jailed or let go.
There was a pair of silver scissors covered in what appeared to be blood.
This man, charged with aggravated manslaughter, had a high PSA score of 5 and 5, and he's flagged as being prone to violence.
So for all those reasons, he'll remain detained.
This man was accused of drug possession and has a history of other charges and failing to appear. He got the highest PSA scores possible, 6 and 6, but Judge Capicella has the discretion to weigh other factors.
I'm also sensitive to the fact that he's working and he's supporting 4 children. So I'm satisfied that I release him on level 3. Condition of your release though, and I very rarely do this, you have to be employed. All right? We're gonna monitor you now. You all right? All right.
He will have to check in regularly with the court before his trial, part of the new monitoring system.
Don't let me down, Mr. Lighty.
So here is an example of exactly what we're talking about. Somebody who scored a 6.6, and you saw the combination of factors that would get you a score of 6.6. Very likely under our old system, there would have been some bail set, probably a high money bail. But here the judge is taking into consideration not just the 6.6 score, but all of the factors, including the fact that this gentleman has a job, is supporting 4 children, and because the judge can now monitor him to make sure he remains employed. We have pretrial services in place to call him and say, you have a court date coming up, to check in on him and have him do monthly, weekly, whatever it is reporting. This individual is out pending the resolution of his case, where under the old system, based on that score, it seems unlikely that he would have been released on anything but monetary conditions.
Not just that. The monetary conditions likely would have been extremely high given his extensive history, right? So he might have had a money bail that he couldn't afford. It would have been a money bail because everyone got a money bail, but it would have been a money bail that would have likely kept him detained.
So just some things to think about under these systems and tools for combating detention, knowing the client, and I don't think we can say it enough, right? Knowing everything about the client through a detailed interview, not just what's in the PSA score. An in-depth knowledge of how the PSA works. We spent a lot of time training our lawyers about the ins and outs and going through each one of those factors and what does and doesn't count, and telling them, we can't always trust the information that's going into the system. So you have to check every offense. You have to ask, why did you miss court that time? Is it because you just didn't show up for court, or is it because you were in the hospital? So you can make those arguments to the judge that maybe the score on paper is inaccurate because there was a reason that person failed to appear, or the difference between, something that would have been considered an arrest before because they were in jail for 15 days prior to getting probation as opposed to 11. You have to have a solid comprehension of the bail statute and know the rules. We did a number of summary documents for our lawyers so that they would have all the citations to the statute and the court rules at their ready. And then understanding the evolving case law, and we are constantly updating our lawyers as these cases develop and as these things are being hashed out in the appellate court and the Supreme Court. I think, too, one of the reasons that New Jersey, we've been so successful early on is that we trained our lawyers to know more about this statute and the set of rules and the law than anybody else in the courtroom. and to go in prepared to make the record in the event that you couldn't persuade the judge to make the record, and but to use everything that they could to try to persuade the judge to release their clients pending the outcome of their case. And early on, when the bail reform took place, we got comments from a number of judges that it seemed like our lawyers were the people in the courtroom who really knew what was going on and really knew what to argue. And it's so important to have a mastery of the nuts and bolts of the risk assessment, as well as your state's rules and the case law, in order to go in and do these hearings. And I think we talked about this. You can argue everything, and don't be afraid to be creative and to argue everything you possibly can to a judge to keep your client from being detained. Revocation. So one issue question was what happens when somebody has been released on pretrial conditions and they violate them. And early on it was, can their conditions get revoked? Well, the answer to that question is no. Sometimes yes. But the court can't revoke somebody's conditions unless there's clear and convincing evidence that no other conditions will satisfy the three goals. So if somebody commits a new offense while on release and they were on level 1 conditions, there's going to have to be a lot that happened to get somebody from there to detention. So conditions can be changed. Somebody can go from level 1 to level 2 or level 3 or level 1 to electronic monitoring, depending on what it is. But as we showed you earlier with the hierarchy, there's escalating conditions. So we're always mindful, and we have to be mindful in revocation proceedings not to let a judge go from release with no conditions to detention.
Which is, to me, this is like a civil rights imperative that the following statement I'm about to make is true. No one in New Jersey can be detained without the state overcoming the presumption, except in the murder and cases carrying life, and carrying that heavy burden of clear and convincing evidence that no condition or series of conditions will satisfy the purposes of the statute. No one, under any circumstances, may be detained unless those things happen at a hearing where the person is entitled to discovery and counsel and has an automatic right to appeal and can cross-examine witnesses if they're called, but more to the point, can call witnesses and offer information of her own.
So we mentioned earlier speedy trial. If somebody is detained, speedy trial rights that are much more carefully put in place and would have much more strict and careful time limits kick in. So if somebody is in custody, 90 days to indictment, 180 days to trial, and the limit is 2 years, excluding only delays that are attributable to the defendant. So within that 180 days to trial, there are excludable time provisions. So if the defendant files a motion, there's a certain amount of time excluded. If there's, if somebody is getting a competency evaluation, so there's certain things that will stop the clock for short periods of time. I don't know all the numbers, and I don't know that we have a number of time to trial yet, because I think we're kind of early in the speedy trial process. But anecdotally, it seems that cases are either resolving pre-indictment or they're getting to trial a lot sooner.
But the bar was low, to be honest, right? Our system was so crummy. People were waiting so long that even dramatic improvements don't. I have to say, I find these limits, the 90 and 180 to me are fine, but for the excludable time. And the fact that the 2-year hard stop is anything but hard because of how they define delays attributable to the defendant, to me is repugnant to the idea of the presumption of innocence. I think when you go out and you ask people how long should someone be in jail while presumed innocent, no one says, 2 years unless certain conditions apply. That seems really long. I think it's useful for New Jersey that we finally have codified speedy trial, that we're not just relying on the Barker v. Wingo reasonableness test, but if I were getting to draft this from scratch, I would certainly have much tighter limitations. But for those of you who are litigating these issues in New Jersey, I want to be really clear. The imposition of a statutory speedy trial scheme doesn't remove the constitutional speedy trial protections that have always existed. So if the delay is unreasonable, even if it's within the limits that have been prescribed by statute, you can still challenge the length of your client's detention. And that's true also if your client isn't statutorily entitled to the speedy trial protection. So if your client is at liberty, but subject to restrictions on liberty. So maybe your client is out, but subject to electronic monitoring, and they are not proceeding with your case to trial. You're not foreclosed from bringing speedy trial challenges just because the statute doesn't provide you relief.
So I'm going to leave it to Alex to talk about the appeals process.
So look, we've talked a lot about the cases that have come through. There have been 6 cases that have been argued. There's another one scheduled to be argued in March. But what we've figured out is there's this discovery right. There's no obligation to call witnesses. The other cases that have been at the Supreme Court have really gotten to the question of, is detention appropriate in a particular case? And this is, to me, and for people who care about liberty, for defense attorneys, the heart of the issue. Because even if we concede that detention might be appropriate for some person, it's never appropriate for our client, right? We can never allow them to do it to our client. And more to the point, if they want to detain our client, they've got to go through us first, right? And we need to be the key to that. And so every case on appeal, we've got to be fighting, because anytime they say detention is okay in this case, we have to remember what it'll mean for our next client. Well, we'll say, well, if it was okay for Mr. Smith, it's certainly going to be okay for Mr. Jones here today. And so we've dealt with SN from Canada. Another case that the court heard, which was really an interesting case, is a case called State versus Mercedes. And the issue there is you've got a defendant charged with really serious crimes. I mean, a road rage shooting and a pretty significant drug case. You've got a defendant with a pretty serious criminal history. I think he scored at different times a 5.5 and a 6.6. But the proofs in the case were really weak. The defense attorney was able to show that the proofs that the state proffered in the affidavit of probable cause were unlikely to lead to a conviction at trial. And the court said, I'm going to release this person. And it makes sense, right? If your lawyer is telling you you can't lose this case, you're unlikely to want to flee. You're unlikely to want to go eliminate a witness because you don't need to. And in that case, the judge released the person. The intermediate appellate court said not an abuse of discretion, and we're waiting to hear from the New Jersey Supreme Court. And I've also said we're talking about this question of how much weight does the recommendation from the decision-making framework have. That's in a case called State versus Travis that they haven't decided yet. So those are the cases that are at the court, but we know there's more. And so the key to the statute is this. The state can seek leave to appeal if the defendant has been released. The defendant can seek leave to appeal if conditions are imposed that she thinks are unfair. But if the defendant is detained, there's an automatic right to appeal. It is a non-discretionary appeal that the court must hear, and the court must hear on an expedited basis. And one last thing on appeals is, one thing that people in other states have talked to me about is that it's really hard to litigate pretrial justice questions because of mootness. People plead, people go to trial and lose and become post-trial detainees, and then the pretrial detention question becomes moot. And one thing that New Jersey courts, to their great credit, have done is they've continued to hear cases even after they're technically moot. There's, exceptions to mootness doctrine that say if the case is of great public importance, or if the case is capable of repetition yet evades review because of the short time of pretrial detention, they can hold on to the case even after the underlying case has been resolved. And so that's why I think we're getting kind of a robust jurisprudence in just the first 14 months into it, because the court has indicated a willingness to try to resolve some of the thorny issues quickly.
So we're going to kind of wrap up here with how is it working, and what have we seen happening? What have we seen happening through 2017, and then where we sit now in 2018?
Since New Jersey ended cash bail, 17,550 defendants were charged with state crimes during the first 5 months of this year. Almost 3/4 were released with monitoring. Close to 10% were released with no monitoring, and 13% were detained in jail. The state jail population has dropped by 19% since the start of the year, due to bail reform, and also the fact that police are issuing more summonses with no arrest for some low-level crimes.
I think the new system is working.
Passaic County Public Defender Daniel Palazzo says cases were harder to win when his low-income client sat in jail because they couldn't post bail. The new speedy trial requirements weren't in place, and prosecutors had leverage to obtain a guilty plea.
And the case just sits and it gets longer and longer and longer. Eventually somebody says, I give up. I want my freedom back.
So those numbers were from the middle of 2017, and just recently the New Jersey courts released in 2018 the statistics for the full year, and it showed that in 2017 142,000 cases were charged in the courts, either on that complaint warrant or the complaint summons. Of those 142,000 cases, 68.9%, or almost 100,000 people, were released on summonses, which means they never even got to this process of detention or release because they were just released pending the outcome of their case. And that is a dramatic increase from where it was in years before. For people arrested on a complaint warrant, our pretrial detention rate is 18.1%, about 8,000 people of those remaining 44,000 people that were released on complaint warrants. For everyone, for the people released on the warrants and summonses, so if you factor back in those other approximately 100,000 people that were released on a summons, our overall detention rate is 5.6.
And I think that, to me, that's the important number, and here's why. If you ask the question, who might have been detained on a money bail that they couldn't afford back in 2016, the answer is 142,663 people might have been detained on a money bail they couldn't afford. Some might have been summoned out, but a lot we know were being charged on warrants and being held on money bail. So 5.6% of arrestees, again, I still think too high, but it's a lot better looking than 18.1%.
And I think, and the most shocking, not shocking, I think, but the most exciting statistic of all, and it's one of the things we talked about in the very beginning, was money bail and this attempt to just eliminate cash bail from the system, even with a statute that does make some room for it. And, sitting here a year after we've been doing this and kind of putting this together and looking back over the year, this statistic even shocked me because as we were going through this, we were wondering at the end of the year, how many times had a judge imposed money bail? How many times in that 142,663 did somebody have money as part of the conditions of their release? And the answer to that question in 2017 was 44. So that's where we are. And as Alex and I think have both alluded to during this, we have come a long way. We have had a lot of success. But there's certainly a long way to go. And all we can say is that we're sort of from where we're sitting right now, things look good, but there's certainly improvements that we can make in the system. And all of that depends on attorneys continuing to go into court, to remember the goal of all of this, and to fight for each and every client to remain at liberty until the point that their case is decided.